Happy Tuesday, 24 June 2025, years after Jesus to you. Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. We're in Bostock, Roman Numeral II, Part B, Gorsuch's opinion for the court. And here we go. From the ordinary public meaning of the statute's language at the time of the law's adoption, which law? 1964 Civil Rights Act, which, by the way, the Republican presidential candidate that year, Barry Goldwater, voted against. Something you might want to think about. From the ordinary public meaning of the statute's language at the time of the law's adoption, a straightforward rule emerges. An employer violates Title VII when it intentionally fires an individual employee, based in part on sex. Um, it doesn't matter. Actually, the statute doesn't say in part. It doesn't matter if other factors besides the plaintiff's sex contributed to the decision, and it doesn't matter if the employer treated women as a group the same when compared to men as a group. If the employer intentionally relies in part on an individual employee's sex when deciding to discharge the employee, put differently, if changing the employee's sex would have yielded a different choice by the employer, a statutory violation has occurred. Title VII's message is simple but momentous. An individual employee's sex is not relevant to the selection, evaluation, or compensation of employees. By the way, just think about this from a non-judicial perspective for a moment. In coming up with this legislation, the Civil Rights Act of 1964, um, think about for a moment the audacity of putting together a cost-benefit analysis devoid of any consideration of costs. When making a blanket statement like the one that Judge Gorsuch just made, Justice Gorsuch, that an individual employee's sex is not relevant to the selection, evaluation, or compensation of employees, um, doesn't that imply that you've done some kind of cost benefit analysis and you've taken a look closely at the costs to the business of having this rule? Seems absurd that such an undertaking has been accomplished by the Congress in 1964. Um, After all, it's not magic that makes a business work. Have to be willing to pay for what the business provides, be it a service or a product. So, who's in the best position to make the determination of what is relevant and what is not relevant in hiring and firing? It seems like it would be the employer that would be the keyed into that reality. But when you're in this mode of fixing evil by legislation, what Thomas Sowell calls the do-gooder mentality, well, you're apt to make decisions about legislation that are all benefits with no costs. Well, that's not the world that this created. This 1964 Civil Rights Act, you're seeing the fruit of it right here, is that a man, a dictionary definition of a man, can come to work having worked somewhere for 20 years, providing what he provides as a man to the company, and who knows exactly what those things are. They might not be interchangeable with a woman. Depends on what it is, what's happening. There are differences between the sexes. But that man can say, and it also depends on the customers. Are we trying to fix customers too? We're trying to fix the marketplace? Um, it's interesting. I don't think that that's the effect that this law is having on American culture. But this man that I'm saying, he could just one day say, "I'm a woman now." And you know what? Even more, he could say, "I'm neither one. I'm no gender at all." He could make something up. And what Gorsuch is saying is that Congress protects these kind of made up arbitrary designations that are completely novel in the English language, that have no precedent or very little. Certainly something that maybe would bother customers, paying customers. And Gorsuch is saying, well, Congress has already decided, they've decided that that shouldn't bother customers. And so, therefore, it's not relevant, which doesn't follow. It's not relevant in, how did he say it? Quoting Price, Waterhouse. An individual employee's sex is not relevant to the selection, evaluation, or compensation of employees. Well, yeah, except for it might be. If you have someone who is bothering customers by making up bullshit, just completely making it up. And as long as they do a good enough job of pretending that where some people could be fooled by it. Actually, I don't see that anywhere in the record. No one has to be fooled by it for the law to protect that individual against um, any kind of adverse action, even when that individual's made up stuff about sex or gender is hurting the company and has a cost to the company. Where's the benefit of this law to the marketplace, to the company? I don't think this law purports to have any such benefit. It just has a command that does not obviously encompass the situations before us here. In fact, when we get to the dissents, you'll see even more what I'm talking about. Let's continue. The statute's message for our cases is equally simple and momentous. An individual's homosexuality or transgender status is not relevant to employment decisions. It just strikes me that Congress would be so bold as to make that statement. He's saying he's Gorsuch is saying that he's channeling Congress. Blame Congress. Don't blame me, blame Congress. Well, the dissents will say, actually, no, don't necessarily blame Congress for that. Blame Gorsuch for that. But we'll get to that when we get to the dissents. I mean, this is an astounding claim. An individual's homosexuality or transgender status is not relevant to employment decisions. That was not true when the law was passed. And as we've already said, it's not even clear what transgender status means. It is clear what homosexuality means, I think. I think it's relatively clear. So I'm not going to focus on that in my comments. But transgender status, this word transgender implies that it's possible to change genders. I don't see that that's anywhere in this record. And homosexuality is obviously possible. And the best evidence for its possibility is its actuality. But I don't necessarily see that with the transgender thing. And I don't think a lot of people do. I think most people don't. I'm not saying it's up for majority decision. I'm just saying that when you're talking about channeling Congress, that is a majoritarian institution. And in 1964, I'm certain that people did not know what you meant by transgender status. They knew what you meant by homosexuality, and I think that they would have disagreed with Gorsuch, but let's just leave that aside. They would not even understand what you're talking about here. They would think you mean a man pretends to be a woman or a woman pretends to be a man. And that's the language that's used in this record. When someone says, I present as, that's the language of pretend. That's acting. And there are actors that get paid a lot of money to act. They're pretending. Like when Dean Cain says, I wasn't really Superman, I was pretending. We get that. We understand that. I mean, back in 1964, people know who Rock Hudson was. They didn't necessarily know he was homosexual. He was pretending. He was acting. That doesn't mean that he's, it doesn't mean that that's his status, what his pretending is. This word status is very misleading. That's because it's impossible, says Gorsuch, to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Now, this is a key sentence right here because of because it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. This is the thesis statement of this opinion of the court. It's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Consider, says Gorsuch. Again, I'm just reading what he says. Consider, for example, an employer with two employees, both of whom are attracted to men. Oh, interesting. What's men? What's this word mean? I notice you don't say that you are presenting as a man. I mean, you just say men. Like, I think he means real men. Doesn't that imply that real men look like something that you can kind of tell? Seems like that's what it would imply to me, meaning that it's perspicuous. It's not hidden what a man is. You don't have to wait. You don't have to ask. The two individuals are, to the employer's mind, materially identical in all respects, except that one is a man and the other is a woman. Oh, what? No language of presenting. All of a sudden, that language is gone. In the context of homosexuality, there's no language of presentment. Okay. If the employer fires the male employee for no other reason than the fact that he's attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague. Put differently, the employer intentionally singles out an employee to fire based on, in part, on the employee's sex. And the affected employee's sex is a but-for cause for of his discharge. Or take an employer who fires a transgender person. Okay, again, what you haven't really defined this term here. We clearly see you have defined homosexual here in this example, but you're not defining this term yet. Fires a transgender individual who was identified as a male at birth, but who now identifies as a female. And this language right here was identified passive, and who now identifies that this is unclear. It sounds like what you're saying is male, but says but lies about it, or who says it doesn't matter as far as whether I am male, which sounds like lying, but maybe it's just speaking a falsehood, or what Democrats refer to as misinformation when it comes to voter ID laws, or I mean voter integrity laws or whatever. Um, so someone who identified as a male. So in other words, someone who is male but says he's not a male. That's what it sounds like he's saying there. And you're saying that is totally irrelevant to an employer's compensation or retainment or promotion. I mean, doesn't the employment decisions im- uh, aren't they related to in some way to customer service? This kind of lying about your gender, this kind of lying to other people about gender, trying to manipulate them and their emotions, trying to trick them as if they're stupid or something and they don't know how to use English. Using pronouns correctly, the third personal pronouns correctly in English is something that any 3-year-old knows how to do. And this is not relevant to an employment decision. This is what you're saying. If the employer retains an otherwise identical employee who was identified as female at birth, this language is killing me here. In other words, is female. The employer intentionally penalizes a person identified as male at birth for actions or traits or actions it tolerates in an employee identified as female at birth. Nowhere in here are the moral issues of lying and asking other people to lie, asking other people to manipulating other people emotionally, their use of language. This is all relevant to customer service in a business. I'm sorry, but you're just wrong, Gorsuch, on this. You're just wrong. And actually, I'm not sorry. Why am I apologizing? This language here was identified. Uh, this language of identification, what does it even mean? Is this ID real? Or is this a fake ID? Is that not relevant? Is it impossible to ask? Are these unreasonable questions to ask? I don't think so. You're talking about managing, you're talking about legislating federal rules for businesses. In other words, creating a liability for employers. And as the kids say, literally making a federal case out of lying about your gender. And I don't mind if you lie about your gender. Don't expect me to believe it, though. And don't expect me to talk that way. I'm free to take my business elsewhere. It's a free country. That can harm the business. It can. Something that harms a business is relevant in an employment decision. It's just false. What you're saying here is false. Now, you're right. Congress, Gorsuch, you're right. Congress can fix this in the sense that they can strip these pathways for liability. I agree. And again, the lawyers love this. Part of the reason I hate it. Okay. But this you don't need this kind of BS language here when you're talking about homosexuality. And that's not because, I'm all of a sudden on the homosexual revolution wagon train here. I'm just saying that for all of our talk about putting homosexuality in the alphabet soup, in the neighborhood of the T people, that doesn't mean that they're on the same team here. They're totally different situations. I think Gorsuch's point about the homosexuality issue is on much firmer ground than the transgender status, so called, which seems to me on quite flimsy ground here. Again, the individual employee's sex plays an unmistakable and impermissible role in the discharge decision. That distinguishes these cases from countless others where Title VII has nothing to say. Take an employer who fires a female employee for tardiness or incompetence or simply supporting the wrong sports team. Assuming the employer would not have tolerated the same trait in a man, Title VII stands silent. But unlike any of these other traits or actions, homosexuality and transgender status, and again, I'm just reading what's actually written. Homosexuality and transgender status are inextricably bound up with sex. No, they're not. No, they're not. You can't even describe what the transgender status is without getting into issues of lying or at least misinformation, as the Democrats like to say. Not because homosexuality or transgender status are related to sex in some vague sense, or because discrimination on these bases has some disparate impact on one sex or another, but because to discriminate on these grounds requires an employer to intentionally treat an individual employees differently because of sex. Nor does it matter that when an employer treats one employee worse because of that individual's sex, other factors may contribute to the decision. Consider an employer with a policy of firing any woman he discovers to be a Yankees fan. Carrying out that rule because an individual is a woman and a fan of the Yankees is firing because of sex if the employer would have tolerated the same allegiance in a male employee. You know, I'm sorry, I have to get in here again. This is a cute example. It's really cute. But these counterfactuals, how in the world are we supposed to know this? I mean, it's just pure speculation, you know? How do you know what he would have done if the woman was a man? How do you know? It's a possible world situation, but it's not the actual world. We have evidence of what the actual world, what happened there. Likewise here, when likewise here, when an employer fires an employee because she is homosexual or lies about her gender. See, it sounds very different when you say it that way. Okay, I was not reading it as written, so I'm going to go back to reading it as written, okay? I don't want to confuse you. When an employer fires an employee because she is homosexual or transgender, two causal factors may be in play, both the individual sex and something else, the sex to which the individual is attracted or with which the individual identifies. But Title VII doesn't care. If an employer would not have discharged an employee but for the individual sex, the statute's causation standards met and liability may attach. What about this? What about if I fire the person because they're lying about their gender? And the firing, since we're using counterfactuals about the Yankees, why not here? The firing would have occurred if the individual was the opposite sex. Then transgender status is not protected. If there is such a status, and assuming arguendo that it is, but it's not. I don't really believe that, but I don't think that there is such a status, but let's just say that there is, and it's identifiable in a non-morally problematic way. It seems like the Yankees example is met there. Um, yeah, that's all I wanted to say about that. Let's continue. But I want to keep reminding you that Congress doesn't have to micromanage the employment relationship to this extent. I don't think that Congress has to micromanage employment at all. But and that's how Barry Goldwater felt. Barry Goldwater felt like the 1964 Civil Rights Act was constitutionally a big problem for reasons that had nothing to do with whether one was a racist or not. It turned out that some racists thought the same thing, but they weren't agreeing about racism. They were agreeing about the bounds of what the government could force private actors to do. And the wisdom of trying to use the federal government labor laws to remake America and make it a better place morally. I don't think that that's what happened. I think what ended up happening was that lawyers got very happy and the employment relationship became micromanaged and people pretend they go along with things and they adopt different ways of thinking because most people aren't very deep and they don't think about things. And it's not that they're being transformed into good people. It's just that they are avoiding trying to get in trouble. And so they go along with the crowd to a certain extent, and um, they still don't think very deeply about things. And it's more complicated to make a living. And good businesses might be forced out. There's definitely a manipulation of the customers and the businesses. And it's not really moral transformation, it's manipulation. Reframing, reframing the additional causes. In today's cases, as additional intentions can do no more to insulate the employers from liability. Intentionally burning down a neighbor's house is arson, even if the perpetrator ultimate intention or motivation is only to improve the view. No less, intentional discrimination based on sex violates Title VII, even if it is intended only as a means to achieving the employer's ultimate goal of discriminating against homosexual or transgender employees. Again, I have to just say, you're talking about transgender as if it is possible to change genders. And you haven't shown it's even possible. In fact, the language that's used seems to imply that it's not possible. That's why you have all this special language, like presenting and was identified and is identified now. And it's a language that distances itself from fact. That language is not being used of homosexuality. Homosexuality is a fact. You don't have to use this language of presenting and identifying as, and was identified and identifies now as. Uh, so I'm drawing a wedge in the alphabet soup, people, of the L and the G, which actually just is homosexual. It should be just an H. H, B, H and B. Okay, I get it. That has to do with sexual attraction. But that implies that an attraction implies that you can perceive the truth about what a man is and what a woman is. If you're really attracted to men, doesn't that imply that you know one when you see one? And if that status of being attracted to men as a man, doesn't that imply, if that status is permanent, which was one of the premises of the so-called same-sex marriage definition change, well, then doesn't that mean that men is something that's permanent? I mean, if you are attracted to men as a man, doesn't that mean that your status as a man is permanent? If your homosexual attraction is permanent, if your homosexual orientation is permanent, otherwise, it seems like it would be fluid. And that premise of the same sex marriage redefinition of the term, so called marriage, would be undermined. There is a tension here, which pointing out. These Democrats would always say, it's just a Hegelian flux. Who cares? Well, I care. There is simply no escaping the role intent plays here. Just as sex is necessarily a but-for cause when an employer discriminates against homosexual or transgender employees, An employer who discriminates on these grounds inescapably intends to rely on sex in its decision making. But again, like if I don't tolerate someone lying about their gender in either sex, then how does this argument proceed? Gorsuch hasn't re responded to that potential objection. Imagine an employer has a policy of firing any employee known to be homosexual. Um, okay. The employer hosts an office holiday party and invites employees to bring their spouses. A model employee arrives and introduces a manager to Susan, the employee's wife. Will that employee be fired? If the policy works as the employer intends, the answer depends entirely on whether the model employee is a man or a woman. To be sure, well, actually, that doesn't follow. That doesn't follow. And so far as I'm reading this, it depends on Susan. And it might be that the manager just doesn't like Susan, whether Susan is married to a man or whether they claim Susan is married to claim to be married in the redefined made up sense, the stipulated sense from Obergefell, to be in that sense married to a woman. It might be that uh, the manager just doesn't like Susan, and whoever was dumb enough to marry Susan will be fired, male or female. And that works with the Yankees. I mean, I don't think Gorsuch even thought about that objection, but I'm not sure what he would say. But again, I'm going to say that the the theme here is even though he's totally wrong as a matter of historical fact, that in 1964, when the Civil Rights Act was written, uh, there's no way that his argument would have been um, plausible to people who voted for that bill. And it's not because they didn't know the logical implications or the legal implications of what they meant when they wrote the bill and what the bill says. It's because Gorsuch is wrong about this. He's just wrong about the implications, the legal implications. But having said that, the transgender status, so called, is on much flimsier ground than the homosexual. And notice he never says homosexual status. Did you notice he never says that? You know, the homosexual homosexuality has been well known for a long time, for millennia. It was nothing that people in 1964 didn't know about. It was not controversial, its existence. Transgender was not even known about. I know that now because it's not known about today. The language of knowledge implies, as we've said on this podcast in a wonderful episode on how do we know things on basic epistemology. It's in the playlist on YouTube. Trent Doherty was our expert epistemologist. Well, knowledge implies truth. You can't know something that's false. If there's not something that really is a transgender status, if it's not possible for someone to change genders, I can't know that. That can't be something I have a grasp on intellectually that has the status of knowledge. Okay, we'll continue. We'll do a little bit more today. Okay. An employer musters no better a defense by responding that is equally happily to fire male and female employees who are homosexual or transgender. Yeah, but but the example you just gave had something to do with a particular woman, Susan, and you didn't respond to that. Title VII liability is not limited to employers who, through the sum of all their employment actions, treat the class of men differently than the class of women. Again, we're talking about men and women as if we know what they are, and it's perspicuous, it's obvious, and it's stable, and it's something you can lie about and misrepresent. And lying is relevant in employment decisions. I don't care what Civil Rights Act of 1964 says. I don't think the Civil Rights Act of 1964 implies otherwise, even though it has other problems, as Barry Goldwater pointed out. Title VII liability is not limited to employers who, through the sum of all their employment actions, treat the class of men differently than the class of women. Instead, the law makes each instance of discriminating against an individual employee because of that individual sex an independent violation of Title VII. So just as an employer who fires both Hannah and Bob for failing to fulfill traditional sex stereotypes, wow, there's a lot of BS in that. You could drive a Mack truck through this. Traditional sex stereotypes. Hmm. Yeah. Sounds like lawyer talk to me. Sounds like sounds like a fun fest for lawyers who get paid by the hour. Doubles rather than eliminates Title VII liability. An employer who fires both Hannah and Bob for being gay. This is an odd way. This is an odd language here. Being gay. Title VII says nothing about being gay. If you look up in 1964 what gay means, it means happy. Um, uh, you can fire somebody for being happy. I don't know why you would. At bottom, these cases involve no more than the straightforward application of legal terms with plain and settled meanings. For an employer to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against individual men and women in part because of sex. That has always been prohibited by Title VII's plain terms and should be the end of the analysis. All right. Well, we're going to get into C next. We're going to get through this whole thing. We're going to nitpick it apart. Thank you for joining me on the Republican Professor podcast. Check out the series we did in the summer of 2023 on the legal definition of marriage, multi-part series. Check out also our discussion with Dr. Thomas Bogardus, a logic professor at Pepperdine University in Malibu, one of my former colleagues there in the philosophy department, on the logical problems with these neologisms in terms of gender. He's got a new book coming out by Rutledge called The Nature of the Sexes. You're going to want to check that out. Check out the discussion I had with Dr. Trent Doherty, and a professional epistemologist. Wonderful discussion on how we know things. Also, check out the interview I did in January, on January 20th, with a gay Republican. I think you'd be very interested in that one as well, regarding the term gay. It's 24 June 2025 years after Jesus. It's a Tuesday coming at you from SoCal. Take care.